Judgment in the matter of Her Majesty's Attorney General, Respondent, against Crosland, Appellant.
This case raises an unusual conundrum. Can there ever be an appeal from a decision of the Supreme Court? It arises in this way. The appellant, Mr Crosland, is an unregistered barrister who is a director of a charity called Plan B Earth, which was a party to an appeal in the Supreme Court in late 2020. The appeal concerned the lawfulness of the airport's national policy statement in relation to the proposed additional runway at Heathrow Airport, and in particular whether the policy was compatible with the UK's climate change emissions targets. Mr Crosland represented his charity at the hearing of the appeal. It is the usual practice for the Supreme Court to send copies of its draft judgments to the parties' representatives shortly before judgments are handed down in public, so that any unintended typographical errors and minor errors about non-contentious details can be identified and put right before the judgments are handed down. This is a collaborative process whereby the parties' lawyers assist the court to make sure that the judgments are as perfect as they can be when they are made public. The draft copies are sent under a strict embargo against disclosing their contents to anyone prior to hand-down. Mr Crosland was sent an embargoed draft of the proposed judgment a week before it was due to be handed down. He was very dissatisfied with it when he read it. He felt that the judgment was misleading. He informed the court about his concerns before hand-down, but the court did not agree with him, and it declined to alter the judgment in the way that Mr Crosland would have wished. So Mr Crosland decided to make public both the content of the judgment and his criticism of it on the day before it was due to be handed down. He knew that this was contrary to the embargo, but he reckoned that he would achieve more widespread publicity for his views about it by publishing it early, rather than making his views known after hand-down in the usual way. He made known the content of the judgment and his views about its inaccuracies both to the Press Association and on the Twitter account of his charity. Lord Reid, the President of the Supreme Court, reported what had happened to the Attorney General, who decided to apply for Mr Crosland to be punished for contempt of court. If contempt is proved, punishment may take the form of a sentence of imprisonment for up to 2 years or an unlimited fine. Where it is alleged that contempt has been committed in the course of proceedings before the Supreme Court, then any such application must be made to the same court, although it may be heard, and was in this case heard, by a different panel of justices from those dealing with the appeal in which the contempt is alleged to have occurred. The Attorney General's application was heard by a panel of 3 justices. It differed from the usual business of the Supreme Court in that it was not the hearing of an appeal. Rather, it was what lawyers call a hearing at first instance, exercising an original rather than appellate jurisdiction. The panel, which I will therefore call the first instance panel, decided that a contempt of court, indeed a criminal contempt, had been committed. It ordered Mr Crosland to pay a £5,000 fine and to pay the Attorney General's costs, assessed at £15,000. Mr Crosland appealed against the finding of contempt and against the order for costs. He obtained permission to appeal, if it were required, from the first instance panel, and the appeal was then heard before a different panel of 5 justices, none of whom had been involved in the original appeal or the hearing of the contempt application. But the Attorney General says that we have no jurisdiction to hear an appeal. The Supreme Court cannot, she says, hear an appeal against one of its own decisions. All it can do is vary or rescind a decision if it has been rendered seriously unjust by a procedural error, as it did in the Crown against Bow Street Magistrate ex parte Pinochet No. 2 in 2000. We have decided by a majority of 4 to 1 that we do have jurisdiction to hear an appeal from a decision of a panel of the Supreme Court, where that decision is made in the exercise at first instance of this court's original jurisdiction to punish for contempt of court. I give the lead judgment with which Lord Kitchen, Lord Burrows and Lady Rose agree. Lady Arden gives a judgment which prefers the Attorney General's argument that there is no appeal jurisdiction. This decision has no application whatever to the exercise of this court's appellate jurisdiction, against which there is no appeal. The reasons of the majority are, in summary, these. While the notion of an appeal from the Supreme Court to the Supreme Court raises some conceptual difficulty, it would be very surprising if there were no appeal from a first instance finding of contempt, which may, in an appropriate case, carry a sentence of imprisonment. But the conundrum is resolved by Section 13 of the Administration of Justice Act 1960, which provides, subject to a few express exceptions, that there shall always be an appeal from a first instance contempt decision of any court, and court includes the Supreme Court. True it is that the Act does not explain how such an appeal is to be heard or by whom, but the Supreme Court's own rules enable us to devise a procedure for the just and fair hearing of such an appeal, namely a hearing before a different and larger panel of justices from those who heard the contempt application at first instance. We have therefore jurisdiction to hear and have heard Mr. Crosland's appeal in full on its merits, in which he represented himself with both skill and courtesy. We have decided that it should be dismissed, and there is no significant disagreement between the majority and Lady Arden about the reasons why. Mr. Crosland appealed on 5 grounds. The first was that the first instance panel failed to take sufficiently into account the sincerity of his views about what he saw as the errors in the judgment when deciding whether the embargo and the finding of contempt was a proportionate inroad into his right to freedom of expression under Article 10 of the European Convention on Human Rights. In our view, the panel did not fail to do so. The embargo restrained Mr. Crosland for only a day beyond the time when he decided to speak. The sincerity of his views was expressly acknowledged and taken into account. Secondly, Mr. Crosland said that the first instance panel failed to take sufficiently into account a letter written in his support by a number of distinguished scientists some weeks after the judgment was published. He said that it was the result of his breach of the embargo that the scientists became concerned about the judgment. In our view, there was no evidence to show any such connection between the scientists' undoubted concern about the judgment and Mr. Crosland's breach of the embargo. Thirdly, Mr. Crosland submitted that the first instance panel was not an independent tribunal. This was mainly because, he said, it was the Supreme Court's own judgment that he was criticising, so that in deciding to bring proceedings to commit him, the Supreme Court was acting as a prosecutor in its own cause. We reject this ground as well. It was the Attorney General, not the Supreme Court, which made the decision to bring committal proceedings, and the first instance panel did not include any of the justices who heard the main appeal. No fair-minded and informed observer would think that there was a real possibility that the first instance panel was biased. Fourthly, Mr. Crosland complained that it was unfair for the Attorney General to seek to commit him for contempt when the attorney had failed to disclose similar misconduct by her department in relation to an embargo on publication on an earlier occasion. In our view, this was, whether true or not, irrelevant to the question whether Mr. Crosland had been in contempt, and did not affect the importance of maintaining confidentiality in the Supreme Court's judgments while under embargo. Finally, Mr. Crosland submitted that the costs order against him was unfair and oppressive. Unfair because he had been led to believe that rules about costs in criminal proceedings would be applied. Oppressive because the order did not take account of his limited financial resources. Again, we reject that submission. The first instance panel applied the correct principles in making its order as to costs. Mr. Crosland was not told that different principles would be applied. His financial means were taken into account. Therefore, the costs order was the result of an exercise of discretion by the first instance panel, which could not be faulted. The result is that Mr. Crosland's appeal must be dismissed. Court is now adjourned.